I think it's too soon to drop it, personally.
I, on the other hand, am super glad that the mask mandate is dropped.
I think that you're in a confined space, and it's still, the variant is still really strong, and I don't want to get sick, so I'm going to be wearing a mask.
Just a sample of the national celebration and concern that followed the Trump-appointed federal judge's decision to roll back the mask mandate on public transportation. Tonight, the Justice Department said it is waiting for the CDC to weigh in. In a statement, DOJ wrote, quote, if CDC concludes that a mandatory order remains necessary for the public's health, the Department of Justice will appeal the district court's decision. That means for now, a federal mask mandate is not in effect. Back with us, Barbara McQuade, a veteran federal prosecutor and former U.S. attorney for the Eastern District of Michigan. She worked with the DOJ during the Biden transition and is a professor at the University of Michigan Law School. Hey, Barbara, so the DOJ believes the mask mandate is a valid exercise of authority Congress has given the agency to protect public health. So why not just appeal the ruling? Why even wait when we all know it's causing confusion?
Well, this is one of the things the Justice Department does. It assesses litigation risk. So even if it believes it's the correct result and that the CDC does have this authority, they have to kind of gauge their likelihood of success. This case was decided out of Florida. The appeals court there is the 11th Circuit. That is one that is populated by a number of Trump appointees and other conservative appointees. And so the worry is, I think, is that if you get an adverse ruling here, you have ensconced this ruling in precedent. It could even go to the Supreme Court, which has recently held that OSHA was unable to mandate either vaccines or testing, you may recall. And so the political climate is not great for pushing this at the moment. So if the mandate is to lapse in May anyway, it may be best to let this one lie for now so that the CDC preserves its legal ability to act in the event of another health crisis that may emerge in the future.
Well, let's say cases do go up and the DOJ decides to appeal. How long could that process take? And would the administration's hands be tied if they wanted to impose a mandate until it's all settled in court?
Yeah, I think that in light of this court's ruling, right, they have to get a judge to grant relief. They could do that if they decided to appeal and were able to get this injunction lifted on appeal so that in the interim it could exist. But I think that if this judge's order is allowed the CDC authority to enter any kind of mask mandate, even if the numbers went up astronomically, it's about the authority of the CDC, not the merits of the decision.
I want to read to you what the Washington Post Paul Waldman wrote in regard to the judge who issued this ruling. Quote, Trump's judges have embodied his perspective on the American system of government, which is that there is nothing inherently worthwhile about any of it. There are no principles worth adhering to, no systems that should command respect, and no rules worth obeying if you don't like the outcome those rules produce. Do you share that concern?
Well, I don't know that I want to lump all of them together. I'm aware of some Trump judges who I find to be very fine judges. But I do think that in this instance, it does seem that the judge expressed some hostility to the authority of the CDC and other administrative agencies. There has been a push by some conservative judges against what is sometimes referred to as the administrative state, sometimes referred to as the deep state, people who have expertise and career jobs in government, who decide things like workplace safety and passenger travel safety. And so instead, this is more of the deregulation, every man for himself sort of worldview. But that's why, elections have consequences. President Trump is permitted to appoint judges that share his worldview. And that is the kind of judge he chose to put in place. And that's why it's so important to remember that the third branch of government is a very powerful one.
Well, let me switch topics for just a quick second. A different federal judge has cleared the way for a lawsuit that wants to disqualify Congresswoman Marjorie Taylor Greene for re-election because of her alleged role in the January 6th attack. Any chance you see that this suit will succeed? What are the issues here?
Yeah, so this is really interesting, Chris, and I think it's great that at least it's going to proceed in court so that we can get some clarity on this. This is the issue that is the 14th Amendment that says that if you're participated in an insurrection, you can't run for public office. It was passed, the 14th Amendment, of course, was enacted after the Civil War. So the idea was people who fought for the Confederacy should not be able to run for Congress. And so there is an allegation against Marjorie Taylor Greene filed with the Secretary of State of Georgia to keep her off the ballot there for her role in the January 6th insurrection. So first, there has to be proof that she did indeed participate in that insurrection. But two, how do you enforce this provision of the 14th Amendment? It's in there, but because it hasn't been tested, there's really no clarity on how that process would actually play out. So I think it could be a useful lawsuit for that purpose. For the moment, the legal proceeding is allowed to go forward. We'll see whether the plaintiffs are able to make their case.
Yeah, it's so interesting. And what qualifies as proof? Does she have to be convicted of something? Barbara McQuade, thank you so much as always.